Hi, everyone. Good morning. Thank you for joining us today for an immigration policy update with the Immigration Institute of the Bay Area. My name is Diana Garcia, and I'm a data and policy analyst with First 5 Alameda County. Here at First 5 Alameda, we are committed to advocating for and achieving equity by focusing on racial and economic justice to ensure that all children in Alameda County are born healthy and that community and family conditions exist that support health, well-being, and growth. This includes advancing programs and policies that respect the lived experiences of historically marginalized communities, including our refugee, immigrant, and undocumented families. We are pleased to host this educational event. The views presented today are the speaker's own views and do not represent First 5's own point of view. But we're really excited today to introduce our presenter, Eleonore Zwinger. Eleonore was born and raised in Germany, and she studied and practiced law there. After her arrival to the United States, she studied for the California State Bar and was admitted to practice law in California. Since 2003, she has been working for the Immigration Institute of the Bay Area, a nonprofit organization that provides high quality, low cost, or free immigration legal services, practicing exclusively immigration law. She currently holds the titles of Senior Staff Attorney and East Bay Regional Director. Today, Eleonore will be providing a brief overview of current immigration law in the United States, as well as new developments and pathways to legal status and citizenship, including DACA, public charge, know your rights, and informational and educational resources for refugees and new arrivals and asylum seekers. So we have 2 hours for today's presentation. We would love to keep this space conversational as possible. If you have any questions that come up along the way, feel free to raise your Zoom hand or type in your question in the chat, and we'll make sure it gets answered during the presentation. We won't be able to answer any questions about specific situations that require a lot of detail about individual cases. Those questions can be referred to a consultation. However, we're happy to answer any general questions that may be helpful to the whole group. And with that, I'll let Eleonore take it away. Thank you all.
I should unmute myself. Thank you very much, Diana. I appreciate it, and thank you for having me again, that I can present to you any updates about immigration law, give you an overview of immigration law, introduce our organization and what we are doing. So I'm really happy and excited that I'm able to talk to you. And yes, please have questions. I think the most lively and most interesting it is when we actually have a conversation. I will make sure that we talk about everything and the things that are on the slides. I probably the slides that I will share with you in a moment, they have also something about know your rights. Luckily, thank God, there is not a lot of immigration enforcement activities going on. So if worst comes to worst, I may not talk about that in detail, but I shared the slide with Leah. So the slide is available. The slides are available to you as well. So, yeah. So let me share the screen so that you can hopefully see everything. Thank you. Thanks for your patience. So let me just introduce our organization, what we are doing. Some of you may already be familiar with us, but just in case. So I have been working for IIBA, which stands for Immigration Institute of the Bay Area, for almost 20 years. And our organization has existed for over 100 years. So we have been providing immigration legal services to people for a long time. We didn't start out like that in 100 years ago, but over decades now, we are focusing, pretty much exclusively on low cost or free and high quality. We really try to make sure that we give high quality services to our clients, and these services are immigration legal services to the low income immigrant community. We are immigration attorneys and Department of Justice accredited representatives, so we are allowed to give legal advice and file applications with the immigration service, and we are also doing in a limited extent removal defense services. Our headquarters are in San Francisco. Then we have 3 offices in the East Bay, and I am overseeing those 3 offices in the East Bay. That's in Oakland, in Fremont, and in Brentwood. Then we have 2 offices in the North Bay, in Napa and Petaluma. Somebody else is overseeing those offices, a colleague of mine. And our executive director is in San Francisco. And then we have an office in Redwood City. And I think that's pretty much it. So we have offices around the Bay Area, and in all our offices, we are providing the same immigration legal services. We do consultations, we do applications for immigration, filed with the immigration service. And like I said, to a limited extent, very limited extent, unfortunately, we are representing people in removal proceedings. And these are our addresses, our telephone numbers. So most of the time, the journey starts that people are contacting us either over the phone or via email, or they see on our website that we have a self-scheduling tool so that people can schedule consultations. But the first contact is usually an immigration legal consultation. And when we have grants available, we can provide that service for free. If we cannot provide it for free, we are charging a $50 consultation fee. And consultations, in my opinion, and I think in general, are very, very important. They are confidential. They are immigration legal consultations, and people share with us what their immigration story is, what they have encountered, and we are checking, and we may have to look at some documents, and we are checking whether somebody qualifies for something. We are doing most of our services still remotely, but we also have people come to the offices, sign documents, drop off things, or have short meetings as needed. But the consultations, we do them over the phone, and if we need to look at some documents, we give people an email address from our office, from our offices, and then we can look at those documents while we talk to them. So immigration legal consultations are very, very important. They are confidential. Even if in a worst case scenario, we have to tell people, which is never comfortable, that they do not have an avenue at the moment to immigrate. At least it is reliable legal advice. And if we don't know something, if this is outside of our area of expertise, then we give people referrals. If it is something that we are doing, but we don't have the answer right at hand, then we research it and we get back to the person. But legal advice is very, very important. And so we encourage people to make an appointment, depending regionally where they are, where they have the closest office, then to make that appointment. Then also we provide immigration legal services, and I mentioned just briefly, but let me tell you a little bit more in detail. Mainly what we are doing is naturalization applications so that people can become citizens, DACA, deferred action for childhood arrival applications, actually the renewals. I will talk about that a little bit more in our updates. Then we do family-based immigration. If the petitioner is here, the US citizen or the lawful permanent resident who wants to bring a family member to the United States, and let's say the family member is outside, we do that process. It's called consular processing. Or if everybody is here and they qualify, we do family-based immigration through adjustment of status. We do a lot of humanitarian applications for victims of domestic violence and violent crimes. You may have heard of it as well. Those are U visa applications, VAWA, Violence Against Women Act applications. I will talk about that a little bit more in detail as well. We do a lot of those. In that area, we have a little bit of a wait list, but we try to, get to everybody as quickly as we can, but the demand is very high. So we have a little bit of wait list, but we definitely do those applications. We do green card renewals. We do removals of condition for people who have a conditional green card. We do Freedom of Information Act requests, all kinds of other applications. What we don't do is employment-based immigration or student visas, applications for non-immigrant visas. Then we usually refer people out, and those are usually private attorneys. Also, if something gets really complex in terms of criminal issues, people inquiring whether they can qualify for something, if it's really, tricky, then we refer them also usually to private attorneys who are specializing in those things. We do, on a very limited basis, applications for asylum, but generally we also refer them out. There are other organizations who specialize more on that. And we do some removal defense. We have some cases going on right now, but we always depend on funding, and mainly on funding from the California Department of Social Services in those cases. And we are waiting to hear from them for the next round of funding. Then we can take some removal defense cases as well. But again, it's very, very limited. Very often we refer people out as well in that context. I would say that's about, in a nutshell, about the services that we are providing. And let's go into, are there any questions in regards to our services? If not, then I start out with what's new. Let's go to the first slide. This is proposed legislation that has been proposed, I think, since early on in the Biden administration, and we do not have any immigration reform. There is nothing, there is no new law about immigration. What the Biden administration has done is they undid a lot of the bad and mean Trump administration directives, and so that immigration became more human and more just again. But the Biden administration did not pass any laws in Congress that would change any immigration law, actually. So these things that were introduced that are listed here on the PowerPoint, they have not gone into law. But what has happened is, and we get on occasion, we get the question that people are afraid if they are receiving public benefits, because I know during the Trump administration, that was one of the targets, that he wanted to make it harder for people, with public benefits. The public benefit situation and the public charge situation went back to how it was pre-Trump. So if somebody has an application pending or was approved an application for asylum, for a U visa, for VAWA, and let's say TPS, all the humanitarian ones, entered the country as a refugee, those applications and those benefits that people got, and also when they got green cards based on that, they are not part of the public charge rule. People who get public benefits under those, there is definitely no problem at all if they get it when they are lawful permanent residents, which means green card holders, or when they want to become citizens. That is not an issue. We sometimes get the question, oh, can I apply for citizenship because I get cash aid or something? And that's, as long as people did not lie in order to get the benefits, as long as everything is legit and they actually, they are eligible for those benefits, it's all good. Where public charge comes into play, and always has, or for many decades, is when in the realm of family-based immigration, when a US citizen or a lawful permanent resident petitions for a family member, and the family members are spouses, children, parents, brothers and sisters. Those are the categories. If they petition for them to become lawful permanent residents, or to enter the United States if they are outside, there is a public charge issue, and the petitioner has to show that he or she makes enough income according to 125% of the poverty line, so that the immigrant, when the immigrant comes here or gets legal status, are not a burden to the government. And if the petitioner cannot, does not have enough money, then there are ways to get a co-sponsor, and under certain circumstances, assets can be used as well. But that is the main area where public charge has always been an issue, needs to be dealt with, but we are back to pre-Trump regulations. And like it shows on the slide, so it only looks at cash assistance for income maintenance. So if somebody really depends on cash, but that would be the immigrant, if the immigrant gets that. And very often, somebody who immigrates, who does not have, permanent legal status here yet, they are often not eligible for that. And often children are getting those benefits, and then that's okay. So it would be cash assistance for income maintenance, and then long-term institutionalized care paid by the government. Also, it means that receiving Medi-Cal or CalFresh, which formerly was food stamps, will not affect an application for lawful permanent residency or citizenship. Or I have seen people have gotten WIC. I have filed many applications for adjustment of status where we listed that the applicant had gotten WIC, no problem at all. But everything needs to be legit. So lying in order to get a public benefit is a problem, and then it could potentially be a problem that goes into criminal law as well. So fraud and so on. So we would not want people to lie about that.
Eleanor, we have a few questions in the chat, I think,
Okay.
on the slide. So one is, would CalWorks affect your application for permanent residency or citizenship?
No.
Okay, and then I think you might have answered the one about Medi-Cal and CalFresh, but are those still being reviewed as part of the process?
Medi-Cal should be fine. Actually, CalWorks, I think what I would do is, I think I have to retract what I said. Sorry. Things that have to do with cash, if people get cash as an applicant, I would avoid that. But if it's food stamps, if it is WIC, if it is Medi-Cal, that's not a problem. But if we are going into cash aid, then I would be careful, honestly.
And then we have one additional question about sharing resources that are specific for asylum cases. But that's something we can share at the end if you have specific contacts.
Yes, we usually, since we are doing asylum applications very limitedly, we have one staff attorney who has a background in asylum cases, and she occasionally takes an asylum case when we have funding. So it's not on a regular basis. So to be honest, I wouldn't really have resources handily available. We have referrals. We can share, referrals where we usually refer people to when they want to apply for asylum. That yes, but legal resources is a little bit harder.
Thank you. Yes, I think they were asking about the referral agency, so that would be very helpful.
Yeah, definitely. And there is also, when people apply affirmatively for asylum, that they are not in deportation proceedings, and there is an application process, but then people can also apply for asylum as a defense in removal proceedings. So those are two different avenues. If they are in removal proceedings and they need to apply for asylum, then usually we refer them to private removal defense attorneys. If they are not in removal or deportation proceedings, then we usually refer them to, and I can say it right away, East Bay Sanctuary Covenant in Berkeley. Then I think East Bay EBCLC, East Bay Community Legal Services, they are also doing some asylum cases. And then the Lawyers Committee for Civil Rights, those are usually the people who we refer to.
Thank you. We have one more question that popped up in relation to public charge. Does applying for CalWorks for citizen children affect the parents' immigration applications?
That should not. But the family should not have to rely solely on that money. So if the money that they get because the children are US citizens, if that's their main income, if that's what they live off of, then I think it could, be possibly an issue, but generally no, because those are children. They have legal status, otherwise they probably wouldn't be able to get CalWorks. They are not seeking for immigration benefits, so that it shouldn't be an issue. But if this is the only money that the family has, then maybe that, because it says cash assistance for income maintenance, then it could maybe get a little tricky. I have not heard it though. I have not heard.
Thank you. Those are all the questions I see in the chat for now.
Perfect. Excellent. So then we have TPS, DACA, and citizenship. So let's start with the citizenship. Trump also wanted to change the citizenship test that to make it harder, obviously, but that was canceled. So we are back to the regular citizenship test, and that's the 100 questions for US civics and history. People need to study the 100 questions. At the interview, they will be asked 10. They have, in order to qualify to pass the test, they have to have 6 right, and people have to read one sentence in English and have to write one sentence in English. So it's back to the same questions like we had pre-Trump, and I have not heard that there are any changes in sight. So that's the easy one. DACA, you probably have heard. I assume that you know what DACA is. If anybody does not know what DACA is, can you please let me know? Otherwise, I just assume that people know about DACA. I will explain DACA anyways, but in DACA there has been well, not really a change, but there was a court ruling, so I wanted to mention that. Diana, do you see anything about?
I don't see any hands up and I don't see anything in the chat.
Okay, so then I assume people know about deferred action for childhood arrivals. And just quickly, that President Obama in 2012 started that. That is not a law change. That was an executive decision, an executive, policy, and that's why it has been, from almost pretty much the beginning, it has been in the courts, it has been contested, but for many years we were able to file DACA applications for young people, and there is a lot of requirements, but mainly it's for the dreamers, people who came here as small children, and they have to fulfill requirements of being here at certain times and having to show documentation and showing that they have they are in school or finished high school and things like that. And DACA has had since 2012, and very unfortunately, a rocky history. And for some time in the beginning, we were able to file those applications. And now for some years already, I would say very much starting with the Trump administration, we can pretty much only file renewal applications for people who have had DACA already, and not really initial applications. When I'm saying not really initial applications, the Immigration Service accepts initial DACA applications, but they are not processing them. It just gets filed and then it sits, and then nothing happens because DACA is in the courts. And very recently, at the beginning of October, the Court of Appeals in the Fifth Circuit said that the DACA policy is unlawful, but they allow people to continue with the renewal applications. And then because the Biden administration also, they introduced new regulations. They wanted to strengthen DACA, and that should come in effect next week, October 31st. But that's also embroiled in that lawsuit, and that part was sent back to the district court. So things are still the same. Like I said, we can do renewal applications. We encourage people to renew their DACA, to reach out to us or other organizations, reliable organizations to renew. But with initial applications, we are not really advertising for that because nothing is happening with that. And in case DACA gets denied, then immigration has all that information on the immigrant. So, but ultimately, we are not encouraging or discouraging. Ultimately, it's the applicant's decision what they do, and if they tell us we should file it, then we file it, but we let them know what the situation is. We are not saying, yeah, great, you can file for initial DACA, and then it's all good. Also, what I should mention is that if people have had DACA and their DACA expires and they do not file a renewal, and they let it expire, and they don't have DACA for a year, and then they want to renew DACA after it has expired for a year, then they will have to do a new DACA application, although it's in the renewal process. But they have to treat it like a new DACA application, and that one is then stuck at immigration as well. They are not adjudicating those as well. So when people need to renew DACA, they please should do it before their DACA expires. Or if it expired, which is not ideal because they are again have unlawful presence, but if it expired, that they should do it as quickly as possible after the expiration, and they should not wait for a year or longer, because then actually they may not have DACA anymore to begin with, and that would be really bad. Let's say it that way. Any questions about?
Yes, we have two questions. One's about DACA, so we'll start with that one. So if someone has DACA and work authorization expired, are they allowed to reapply for the work authorization?
Yes, so that means the work authorization goes parallel with the DACA approval. So people who have DACA, they get the work permit or work authorization for exactly the time that DACA is valid, and that's 2 years. So when I hear that the work authorization has expired, that to me means that the DACA has expired as well. So if that has expired, hopefully it's only not a long time. Hopefully, basically, it's less than a year. Then they should definitely go and renew the DACA. If it has expired for a year or more, then we are in the situation that they would have to file a new DACA application, start from scratch, basically, and then it's stuck. But hopefully, that's not the case.
Thank you. So we have two additional questions. I think these two pertain to pathway to citizenship. I'll do the last one that came in and then I'll go back to the first one. So can a person or a man who was in the US when he turned 18 and did not register with the Select Service become a US citizen if he is now over 35?
Yes, but what we will have to do, so that has nothing to do with DACA, but that's okay. And we will talk about citizen, that's totally fine. No worries. Yes, we have that on occasion that people did not register. What we then have to do is we have to explain in an addendum that, I would assume the situation was maybe that person did not go to school here, started working, was not aware that the person would have needed to sign up for the selective service. So we have kind of a prepared addendum that people with the citizenship application where we explain what the situation was, and then the person apologizes, and usually we say, and hopefully that's meant, I would assume that it's meant honestly, that if they had known that they would have needed to register, then they would have registered. And normally that is okay. I have not had a situation where that was an issue. But we have to do this extra thing and explain it. And the selective service registration also applies to people who are here without documentation, who are not here legally. So one would think, I haven't been here legally and now I'm applying for my green card. I have the possibility I did not have to register. That's not the case. So even if somebody is here without permission, they would have to register. The only people who do not have to register are people who are here between the age of 18 and 26, let's say on temporary visas as visitors or as students, or people who are, on those visas and they are supposed to go back. If they were during that time here on a valid visa like that, then they are not expected to register.
Great, thank you. And then we have one more question, but I think it's about the previous slide. Is it okay?
So,
That's okay? Okay.
everything is good.
All right. Okay. I'm just going to throw them at you.
Yeah.
So if an undocumented parent has a child that is a citizen and has special needs, if they apply for SSI, would their legal status be affected if they want to apply for residency in the future?
So if the disabled child is a US citizen, that disabled child should apply for every benefit that's possible. That is a US citizen. This person has the right, they should use the benefits that are available to them. And let's say if later on that US citizen child that say petitions is able to petition for let's say the parents, the fact that the petitioner gets SSI is not a problem. Now, the only thing is SSI is a means tested public benefit. It does not count as income. So if a petitioner does not have income, the petitioner needs to do the affidavit of support, and this person would have to file the affidavit of support anyways, but whether the person has any income or not, but then we would look for a co-sponsor. So it should not affect if the US citizen receives SSI, it should not affect anything. The only thing is we may need a co-sponsor in a context of immigration.
There's one more question in the chat that just came in. If someone is illegally working under a fake social and claim pregnancy, disability, or paid family leave benefits, does that count as cash aid and affect immigration applications in the future?
So that is, I assume that those are benefits that are based on employment, right? So if somebody uses a fake social, let's say, to work, and this person can get all the benefits that they have based on their work, then those benefits are not public benefits. If this is more like, you know, if it is I'm not sure whether paid family leave and things like that, it seems to me like this is, you know, in conjunction to employment, then that should be fine. It's not food stamps or cash aid or, you know, or SSI, which are means tested public benefits. I think it is more related to work. It should not be an issue. I'm not an expert in those particular, you know, benefits, but like, for example, unemployment benefits, they are not public benefits, or they are based on employment because the person has you know, worked and, you know, then was laid off, and this is not a public benefit. Or yeah, I would say I would think that paid family leave is not a public benefit.
Thank you. Those are all the questions I see in the chat now. But folks, feel free to add additional ones as they come.
Okay, great. So we talked about DACA, and I will explain DACA a little bit more, but it seems like people know what DACA is. And I just wanted to mention that we can do renewals. Also, what I wanted to mention in regards to DACA is people who have DACA, they can also apply for permission to travel outside the United States under certain circumstances. So we always have to check what is their immigration history. We don't want that there is some deportation around. We just want to be careful. That's where consultations also come in again. But if somebody has DACA and let's say came here one time without permission, was not detected, has not left the United States, but wants to travel, and the three reasons under DACA where people can travel is for humanitarian purposes. Usually it is to visit an elderly, let's say sick family member in their home country. It could be for work purposes and for educational purposes. If people have that possibility to travel. I recommend that people use that, ask for that permission. It takes a long time anyways. In an emergency, it can be sped up, but so that people can leave the United States, travel, and then they come back with permission. Then it's especially for people who did not enter the United States with a visa, but for people who entered without a visa, if they have that travel, then they are paroled in. That's legal entry into the United States. And then, for example, if they have a qualifying family member, a US, very often it's a US citizen spouse, then they can apply for their green card here in the United States and don't have to leave the country with having to do an extreme hardship waiver and things like that, which are much more work, less secure, and yeah, is a much bigger deal. So we are doing quite a few advanced parole applications, but again, we need to check every case. Every case is different. We need to check people's immigration history to see whether it's safe that people leave under that advanced parole. We would have to get, the reasons why they need to travel. Often we need a letter from a doctor and things like that. We need to translate this. We have to explain the family relationship and, send the appropriate documents. But, it comes. It's a good thing. And I encourage people to do it if it's the right thing to do, as long as we have DACA. I hope DACA doesn't go away, and I hope actually we get something better than DACA, but you just never know. So if people have that possibility, it would be good to check about this. And even if people do not have a US citizen or lawful permanent resident partner, for example, right now, if they can do this travel, that advanced parole, that legal entry, that does not go away. People need to keep the record of that. They need to keep their passports and everything, that we have the proof. But even if 10 years down the line, they then have a partner who they want to get married to for the real reasons, not for immigration purposes, they can use that legal entry. So, and also what I want to say in that context is, sorry, we have heard of some organization or some attorneys or something where they have, and I do not know whether those are legit travels or not, where there are some courses that people may or may not take, let's say in Mexico, for example, so that they have this educational component for the advanced parole application. I have heard it now twice, and I do not know, frankly, whether these things, it may be legit, and these people may truly travel for educational purposes. But the way clients talked to us about it, it was a little questionable. So I am not sure, but I just want to say, if somebody has DACA and wants to apply for advanced parole, please check with reliable, sources like us, like Catholic Charities, like other, legit and ethical immigration legal service providers before you sign up with something that might be shady, and then that could bite people later on. If there was some fraud involved, then it gets complicated. I just wanted to mention that. So DACA, advanced parole, travel with that is possibly a good thing, but we would want to check it on a individual basis, but it can be a really good thing. Any questions for that?
No additional questions at this time.
Okay, great. Then let's talk about TPS. And there was a little bit back and forth with TPS as well. So TPS Trump, of course, also wanted to get rid of TPS, and he tried, but then it also ended up in lawsuits. Particularly, I think it's known for people from El Salvador, and I think this has still not been resolved. So it looks like it sounds. I checked on the website, on the immigration website yesterday, that TPS automatically continues for people from El Salvador and other countries who are affected by that. They had the employment authorization based on TPS also extended until December 31st. So I have not seen anything, but I would assume that then people would have to apply for new work permits again. And sorry, I should explain, a lot of people may know what TPS is, but a TPS is temporary protected status. This is for people where in their home countries there were natural disasters or there were political issues. Like, for example, we have TPS now for temporary protected status for people from Venezuela, from Ukraine, very recently for Ethiopia. So and other countries, Afghanistan also, so where there are really serious political issues, and also could be natural disasters as well. So that people who are here from those countries, they can stay here and can be safe here. Actually, DACA is kind of modeled after TPS, after temporary protected status. And TPS always needs to be reauthorized and continue. So it's not something that's indefinite. There is always this uncertainty whether it continues or not. With El Salvador, for example, it has continued, I think, since 2001. And that's why it was such an awful thing when Trump suddenly wanted to get rid of it. People have lived here for a long time on TPS. So there is quite a few countries under the Biden administration has been pretty good about designating countries for TPS, but there was also something that there was also a little bit of back and forth in terms of what status it is and whether people can obtain lawful permanent resident status based on TPS. If they have, let's say, a family member who could petition for them, and having TPS in itself gives them that legal status and that legal entry. That was okay for a while. That is not okay anymore. But what works again is, like TPS, like DACA, also has the possibility to ask for the permission to travel. And it's called also advanced parole, like with the DACA. The thing is with TPS that people don't need a specific reason to travel. They only have to ask for the permission, but any purpose is good. And for a while, it was like this permission when people enter the United States and are paroled in, that would not count to then qualify to get lawful permanent resident status here in the United States. But that was fixed again, and fixed very recently. So people who have TPS, who traveled on advanced parole based on TPS, come back, are paroled in, they can again, based on that, apply for lawful permanent resident status if they have a family member who can petition for them, for example. So that's also a new development, again, that I wanted to mention. I should also mention, with TPS, temporary protected status, and DACA, those are temporary protections against deportation. They themselves do not lead to lawful permanent resident status. So you cannot say, oh, I have had DACA or TPS for an X amount of time, now I can become a lawful permanent resident. That does not exist. I think there are proposals for legislation to do that, but there is nothing. However, if people are on TPS or on DACA, they can switch to a different process. If they have a family member who can petition for them, then we can check whether they qualify for a green card. Or if they have been a victim of a violent crime or domestic violence and they qualify for a U visa or for VAWA, they can switch from TPS or DACA to something else. So it's not like people are locked in TPS and DACA. They can switch if something is available, but TPS and DACA themselves, they don't give them a route directly to lawful permanent residency and later citizenship. Are there any questions?
Yeah, there's just a quick question. Can you repeat what you mentioned about the December 31st extension?
Yes, so the TPS for Salvadorians, it says that it continues basically automatically, the TPS itself, until, you know, further notice with the lawsuit. And again, like with DACA, the work permit goes parallel for exactly the same time that people have TPS, like with DACA. Yet I think immigration had automatically extended work authorization until December 31st, 2022. And that's still on the website of the USCIS website. So they didn't say anything what is next. So normally when a work permit expires, then you have to apply for renewal, or maybe they continue extending it automatically beyond December 31st. I don't know. But if TPS gets extended longer, then also the work permits will be extended as well. The question is only, do now people have to apply for a renewal again, or will they automatically extend it further? So I don't know yet.
I have a question. What is the difference? So when you mentioned the U visa, and then you mentioned another one, the VAWA, what is the difference?
I will explain.
Okay.
Visa and VAWA, please hold on. I will go more into detail about that.
Okay.
When we talk about the general things, I just wanted to, I wanted to do the updates first, and then I will introduce the different forms of relief more in detail, and for sure U visa and VAWA. Okay, great, thank you, thanks. So then I just wanted to say with the updates, you probably have heard about processes that's not, I leave that up here because that's still if people want to, make appointments. But what I also wanted to say is there is a new process for people from Venezuela to come to the United States if they feel unsafe. They have to apply from outside. That process is modeled after the process that they started for people from Ukraine because of the war that's happening there. And things in Venezuela are not good either. So the government started a process for people from Venezuela as well. And just in a nutshell, it goes like they need to have a sponsor here in the United States, and it needs to be a person. It cannot be an organization or a business. And that person needs to fill out a sponsorship form. It's a form I-134, and then the sponsor gets vetted. And then if that sponsor is accepted, then the person who is abroad, the person who wants to come in, goes through an online process with the immigration service. They have to make an account, and it goes through email and things like that, so that they get vetted. They have to, you know, give some biographic information and that show that they are eligible. And it also involves the customs and border protection, so that ultimately at the end of that process, and that's pretty much the same for Venezuelans and also for uniting for Ukraine for Ukrainian citizens, that they then at the end of the process, they get the permission from immigration, and I think in this case it would be customs and border protection, that they get allowed to enter the United States, and then they receive again parole. They are paroled in, so they enter with permission, and that then they are allowed to be here in that parole status for 2 years, and they get also they can apply for a work permit for those 2 years as well. Once they are here and they have that parole, that they then apply for a work permit. I do not know whether this parole can be extended. I looked on the website, I couldn't find anything, but both say that people then can enter if they qualify, if everything looks good in that process, that they then will be able to be here legally under parole, and they get a work permit for 2 years, and they get a work permit for 2 years. The process is on the USCIS website, so if people are interested, they can also and could possibly qualify. They could look there. But this is for people who are outside the country and they want to come in, and that is particularly for Venezuelans and for people from Ukraine. Then we have something for people from Afghanistan as well. Afghanistan people also have TPS as well, but they have the humanitarian parole. That is more like the classic humanitarian parole, where there is a fee involved and things like that. And I remember that when everything collapsed in Ukraine, not in Ukraine, in Afghanistan, that people, you know, they approached us. They tried to apply for humanitarian parole for people who are still in Afghanistan, who didn't make it out, or maybe they are in Pakistan or other countries. And then it gets really, really difficult. And so we actually, we stopped doing those applications. One is because we don't have the resources to do all these applications. And the other thing is, I think the filing fee was relatively steep. It was over $500, if I remember correctly. It may not be. And then there were several family members. And then we didn't know whether immigration will accept or will actually approve them. And then later on, we heard that actually the approval rate, that it took forever, that they didn't have enough resources there. They were not prepared for the influx. And then also very few were approved. And then we said we almost feel unethical that we take the money and people have these filing fees, and not just for one person, but for several people, and they spend thousands of dollars as with immigration fees, and then it may not even be approved, or it takes forever. So we have gotten, you know, very careful about that. For Afghans, they don't have that type of parole like what I just described to about the Venezuelans and people from Ukraine. However, with people from Afghanistan, if they have family-based petitions pending, and let's say they are here, then we are checking whether we can, you know, continue with those family-based petitions, and if people can leave Afghanistan and maybe process their case in a neighboring country. For example, in Pakistan, we have people who go through Pakistan. That's one thing. Other people, they may have made it out of Afghanistan and actually were paroled in, then there is a process that they then, once they are here, we are checking if they can apply for asylum, or maybe there is a family petition already there, and that can be continued, and they may not have to leave the United States. So we are checking on that. And then there are these SIV visas. Those are special immigrant visas. And those are for people, Afghan citizens who worked with the US government. And some people may have started that process while they were still in Afghanistan, and then the consulate, the US embassy and representation closed down. So there are different variations where people could be in that process. And also they changed the process over time a little bit. So, but that's also something to be considered, and people may continue that process as well, and maybe can finish it, you know, while they are here in the United States. We would have to look at it on a case-by-case basis. So those things are going on as well. Are there any questions in that regard?
I don't see any. Thank you.
And then I wanted to, thank you, thanks Diana. Then I wanted to mention one more thing, and there we have to be a little bit careful that I'm not saying something that what it not is. People may have heard that when somebody is here in the United States and they had their visa expired and they have stayed in the United States for a year or longer, that then when people leave the country, they trigger 3-year bars, 10-year bars, and there is also a permanent bar. That is a big subject in immigration law, and we always have to check whether people accrued unlawful presence and whether they have any bars, or they were going back and forth and they trigger any bars. So that is generally a big deal in our work, and we always have to check it. Now, there came something out recently, I think it was also through the court process, that if somebody, let's say, and that only applies if people can fix their status and can become lawful permanent residents from within the United States through adjustment of status. So if somebody, for example, came here a while back with a visitor visa, they overstayed, let's say, for more than 6 months, but less than a year, they left the United States and they came back again with a visa, for example, or yeah, they came back with a visa. That's the safest way. And now, after they came back, they didn't lie, they just were accepted again with their visa, and now they have lived here, even as their status expired, for more than 3 years. Then they do not need a waiver of that inadmissibility. Those 3 years, they were able to pass those 3 years within the United States. It used to be that people could not serve that time, so to speak, here in the United States. They would have to leave, and then they would have to ask for a waiver. Or if they triggered that, they would be able to adjust status here and would need to ask for an extreme hardship waiver, which is a lot of work, and it's not a given that people get it. So that if people have spent those 3 years here or more, and they qualify to get their status here, they do not need that waiver. Same thing if people overstayed here for a year, left the United States, came back again with a visa, and they have since then lived here for 10 years, they also do not need a waiver anymore. Usually, if somebody who has been here without permission for 1 year, left the United States and came back legally again, they would trigger a 10-year bar. So if people then have served have been after their last entry, been here for 10 years, and then want to apply and qualify to apply for a green card, let's say based on marriage to a US citizen, or let's say they are a parent of a US citizen, and they have the proof that they entered legally again, they do not need that waiver, that extreme hardship waiver. So for us practitioners, it makes a big difference. We always check on that. Now, where it does not work is if somebody entered the United States illegally after April 1st, 1997, stayed here for a year or more, leaves the United States, and comes back illegally again. These people, then there is a 10-year bar. Actually, it's a permanent bar, but they cannot spend 10 years here and then fix their papers here. That does not work. That is a bar that is not forgiven by staying here for 10 years. So that's it. It goes a little bit into the weeds, but I wanted to mention this here, that under certain circumstances, if people trigger a 3 or 10-year bar, and it's usually for people who were going in and out with visas, and they have stayed here after their last entry for 3 years, if they triggered a 3-year bar, or for 10 years if they triggered a 10-year bar, and then have a possibility, and it's usually as an immediate relative through the petition by a US citizen spouse or by a US citizen son or daughter, then they may not need that waiver. Does that kind of make sense, or is that a little bit too technical? Do people have questions about that?
I don't see any questions, Eleanor. Thank you.
Okay, I wanted to mention it because it is semi-revolutionary what happened in that context. It does not apply to everybody, but it applies to some people, and it is, for us, it is a big deal. And I wanted to mention it in a way because so that people get it in the right perspective, not that it says, oh, the 10-year bar, the 3-year bar is not an issue anymore. It's not like that.
There's a question whether this applies for visa holders. Is it just for visa holders?
I would say it's mainly for visa holders, because if people are going back and forth without permission, then we are in the permanent bar realm, and then it doesn't work. So I think where we see it is if somebody was going in and out after overstaying with visas. I think that's the most likely scenario. And it's only then for people who can then apply for legal status here in the United States, because if you have overstayed for a year or longer and you cannot get your paperwork here in the United States, but you have to do consular processing because you don't qualify for getting it here, then the moment you leave the United States, you actually trigger the 10-year bar again. So I think overall it's just, I would say, mainly in the context where people were going in and out with visas, and they have the proof that they did, and then they can immigrate as immediate relatives through a U.S. citizen spouse or parent, U.S. citizen spouse, parent, or adult son or daughter who is 21. But it is something that we are checking. So if somebody thinks, oh, maybe let me see if that qualifies for me, then we should check it. It applies, I would think, or could apply if people entered with a visa, then let's say they overstayed, they traveled again, but they have a US citizen child, for example, and that child now is 21, and that child cannot be a qualifying family member for an extreme hardship waiver. So often previously we had to tell people, oh, although you entered legally, you don't qualify for adjustment of status. Now with this, if they triggered the bars, but they were coming back and forth legally, then there is the possibility that the children, the adult children, can do the process for them, for the parents. So that's why I wanted to mention it, because it opens maybe a small window for some people to qualify. Now, let me see. And here we have it. We had the question, unemployment insurance is not a public benefit, but you must have valid work authorization in order to be eligible. So again, if people, even if it's not a public benefit, if people qualify for something, they have to make sure that they do things legally so that they are not triggering another problem, which could be a criminal problem, a fraud problem. And then also treatment, vaccines, and tests for COVID-19 are not considered public benefits, and you should not hesitate to use them. And then if there is more COVID-related things, then we have something on our website also, and then COVID-19 resources as well. Any questions about the updates? It doesn't seem like it. So then I will go more into detail on some of the forms of relief, and particularly then also U-Visa VAWA. So DACA, we talked about it. This slide shows the requirements. Those are the requirements if we could also file initial DACA applications. People can file, but then, you know, it doesn't go anywhere. And the renewals, they have already qualified. Although I have to say, with the renewals, we always check whether in the meantime people committed crimes while they had, let's say, the DACA for the last 2 years. We always check, did they leave the country without permission? Did they commit crimes that may make them lose DACA? And one big one is a DUI. A DUI is a significant misdemeanor, and if somebody has a DUI, then they don't qualify for DACA. If somebody had DACA and they need to renew, a DUI would preclude them from renewing. So there it becomes also important that people, if they have something like this, I mean, people just should not commit crimes. So that's, I think that's the basics. But if something really happens, and let's say somebody has a DUI while they have been on DACA, they should really get legal representation. And this legal representative, this person, the lawyer, the attorney, needs to know that this person is an immigrant, and immigration issues are important in that criminal case, so that maybe they can reduce that case to a wet reckless, because a wet reckless with showing some good equities and things like that, and rehabilitation, that has worked for renewing DACA. So, but if somebody, for example, has a DUI or another significant misdemeanor, then it may be that a renewal doesn't work. So we always check that. And when we have renewal applications, we also check if people, you know, qualify for other better options than DACA. I think I don't go over all the specific requirements, because initial DACA filing is not really, you know, that good right now. And I think you are aware of DACA anyways. Plus you have it on the slide, so you can always double check it. And then here we have it, that, you know, renew DACA and then file for advanced parole. Then citizenship. So Citizenship, in order to become a citizen, a person first needs to be a lawful permanent resident. I'm talking about naturalization process. There are other processes. Some people, they may be US citizen by birth if they have a US citizen parent at birth and they fulfill the requirements. We always have to check on a case-by-case basis about that. Or let's say a US citizen petitioned for a minor child, and the child, as soon as the child comes to the United States, lives in the custody of the US citizen parent or parents, then they may be US citizens also the moment they become lawful permanent residents. We have to check that too. But I am talking more about the process. Somebody, became a lawful permanent resident, either through family-based immigration, through refugee status, through asylee status, or through U-visa VAWA status, etc. And now they are lawful permanent residents. When and how can they become US citizens? So that's a process that we are helping people with, and it's encouraged that people apply for citizenship, because once they are a citizen, they can vote, they can travel and live outside the United States without any restrictions, they can petition for a little bit more family members to immigrate than a lawful permanent resident, and it also goes faster. They actually can petition for parents, siblings, and married children. Lawful permanent residents can only petition for spouses and unmarried children under the age of 21 and over. If you are a US citizen, you cannot be deported anymore. You can also can apply for a wider variety of jobs. Public benefits is not an issue. You don't have to worry about public benefits. And, some countries allow dual citizenship. The US allows dual citizenship, for example. So those are the benefits to become a US citizen. And in order to qualify, you need to be 18 years or older. You need to have been a lawful permanent resident generally for 5 years. You can apply 90 days before the 5th anniversary of your green card. If somebody is married to a US citizen and the citizen spouse has been a citizen for at least 3 years, they don't have to wait for 5 years to become a US citizen or apply for US citizenship. They can apply for US citizenship after being a lawful permanent resident for 3 years. But then they have to show that they have been living with the US citizen spouse for the last 3 years. So that's an extra requirement. And they also can apply 90 days before the 3rd anniversary of their green card. Then people have to show, and that is listed in the application, because people have to list their trips during the last 5 years or during the last 3 years. They have to show that they have been at least half of the 5 years or half of the 3 years physically present in the United States. So we always have to be very careful and check that that's the case. If people don't have that, they don't qualify for citizenship. We wouldn't apply. Also, we have to show, or we have to make sure that people did not abandon their residence. That is also generally if people have longer absences. If a lawful permanent resident has not been in the United States for more than 6 months out of a year, then things can get complicated. And people may not, under certain circumstances, qualify for citizenship, or if immigration thinks, and it's the burden of proof is on the government side, if immigration thinks that somebody actually abandoned their residence, that they did not want to be lawful permanent residents anymore because they have been outside the country for so long, then they actually can lose their lawful permanent resident status. Then people have to show that they are a person of good moral character. So there we have to look into criminal issues during the last 5 years. Is there anything that affects the good moral character? Do they file and pay their taxes? If they have to pay child support, spousal support, are they doing that, or are they behind with that? So there we have to see if things, affect the good moral character, and if that's the case, then it needs to be fixed. If there are criminal issues, then we also even have to check further: are those criminal issues within the 5 years or beyond the 5 years? Do those criminal issues make the person deportable? Then we're talking, is there a risk in losing your lawful permanent resident status when we apply for citizenship? Or is it just a good moral character issue that can be fixed if they take care of the criminal issue, and if they can show that otherwise, they are a good person and they have rehabilitated and nothing happened. So we have to check on those. With naturalization, it is a very happy application, and it's the last step, in order to finalize the immigration journey. But we have to be really careful. We ask people a lot of questions: how they got their green card, was everything okay, was everything disclosed, was the process, was everything correct, did they commit crimes while they were lawful permanent residents, or did they stay outside the country for a long time? Because all these things could affect the application, and we want to know before that, because worst case we tell people no, you shouldn't apply, or you don't qualify, then applying, and then we are in a situation where they not only do not grant naturalization, but people are at risk of losing their lawful permanent resident status. So in many cases it's all good, but we take it seriously, and we ask a lot of questions. We ask people for documents and so on. Also, there is the requirement for naturalization that people speak, read, and write basic English, and they pass the US history and civics exam. I mentioned about that early on, that there are these 100 questions. People will be asked 10, and then they have to have 6 right of the US civics and history questions. But also the interview normally for the naturalization, which is at the end, before hopefully they get granted citizenship, the interview will be in English. So the officer who interviews will ask all the questions on the application form, plus the test about civics and history. They will ask all that in English. And if people cannot do that, then the officer will say, well, in this, I cannot give you naturalization right now, but with every application, you have two possibilities. So if you didn't pass in the interview in the first one, you get a second possibility. If you don't pass in the second interview, then the naturalization application gets denied, and then people have to start from scratch. Now, there are exceptions. If people are 50 years and older and have been lawful permanent residents for 20 years, they can do everything in their home, in their natural language, but they will still have to study the 100 questions. If people are 55 years old and permanent residents for 55 years old and permanent residents for 15 plus years, they can do everything in their own language, in their native language, but they still have to study the 100 questions. If somebody is 65 years old or older and has been a permanent resident for 20 plus years, those people, they can do the interview in their own language, and they only will have to study 20 questions, not the 100 questions. And then they are asked, and those are usually the easier questions. And then they only have to answer, 10 questions and 6 right. The other thing is that I want to mention is, and you may have heard about that as well, is the disability waiver. That's the form N648. So if somebody does not qualify for the 50-20, the 55-15, and the 65-20, but they do not have the mental capacity that they can study English and civics and history, and immigration is very, very strict about that, then they can file that disability waiver, and then they don't have to do any tests, and they don't have to do anything in English. Now, the thing is, the disability waiver, it needs to be done, that form N648 needs to be done by a mental health professional. It could be a psychologist, psychiatrist, could be a licensed family and marriage counselor. I mean, somebody who is licensed to judge the mental capacity of a person. It could be also a general physician, but this application needs to show that that person has been a patient and has had services from those professionals, and they have to explain in detail what they diagnosed the person with, and have to do like mini mentals and other tests, and it has to be documented in that form, and has to be explained in detail what they, like I said, what they diagnosed the person for, and what is the connection between the diagnosis and why they cannot study those questions, and why they cannot learn English. So that the classic diagnoses are dementia, Alzheimer's, chronic depression, things like that, where people are really impaired in their cognitive functioning, and they don't have the memory that they can retain information. And if that is shown and documented properly, then they can qualify for the disability waiver. If somebody has high blood pressure, needs to take medication for that, or maybe had a stroke, but otherwise the cognitive functioning is still there, that may not work. But it could be that if some people, I had a client who had schizophrenia, and that person had to take very, very heavy medication that also affected the thinking ability. That person could qualify as well. So those N648 waivers, they are possible, but they need to be done the right way, and it needs to be all honest. Immigration is always on alert that somebody may sign something and it's not really the case. Some medical professionals, mental health professionals, like we have shady people in the attorney realm. There are some people there as well who maybe just do that. Immigration is very much on alert about those things. But if it works, then it is a good thing. So that's kind of in a nutshell about naturalization. Are there any questions about naturalization?
I don't see any at this time. And if I do see questions, I'm going to hold them till the end so that we can go through more content, since there's only about half an hour left.
Yeah. And I will keep it very short with the family-based, because I want to go more into the U visa VAWA. And I had already mentioned family-based petitions in the context of affidavits of support. I have explained there is, adjustment of status, there is consular processing, and generally it is if somebody is a US citizen or a lawful permanent resident, they can petition for certain family members. And it's either through the process of consular processing or through adjustment of status. And here we have it. Citizenships can petition for immediate relatives where there is no wait list. The petition is done and then it continues without interruption. For spouses, children, unmarried and under the age of 21, and parents if the citizen is over the age of 21. They also can petition for other relatives, but then there is a waiting period and some of it can be really lengthy. And that is for married or unmarried sons and daughters of any age, so 21 and above, and for siblings. That's who US citizens can petition for. Lawful permanent residents, green card holders can petition for spouses, children under the age of 21, and sons and daughters over the age of 21, and they need to be unmarried. If somebody has filed a petition for an unmarried son or daughter, and they then get married while this petition is pending or while they wait for their time to take the next step of consular processing, that petition is gone. That person cannot immigrate anymore. So I just want to say this, that lawful permanent residents can only petition for unmarried sons and daughters or unmarried children. And this is the process. If you are inside the United States and the person, the immigrant is an immediate relative, for example, is married to a US citizen or has a US citizen child under the age, over the age of 21, for example, then everything gets filed together. The family visa petition and the application for adjustment of status, the work permit application, everything gets filed together. Processing times are lengthy, but the person does not have to leave the United States. But we will have to check whether the person qualifies. If the immigrant is outside of the United States, we have to start out with the family visa petition. If a waiver is necessary for unlawful presence, we can do that as well at the same time from here. But then once the I-130 is approved, the family visa petition, the case gets referred to the US consulate in the person's home country. Then there is more paperwork that needs to be done. It's all actually pretty much electronically. At the end, the person has an interview at the US consulate. And then if everything goes well, the person gets an immigrant visa, enters within, that visa is good for 6 months, enters the United States with that immigrant visa and the packet that they received from the consulate. And then they have to do something online. So then actually that the green card gets produced and they are lawful permanent residents and can live here. So that's, and in this process, in the family-based process, that's where we have the public charge and where we have to do an affidavit of support. So that's the part where that is necessary. We talked already about TPS. Let's skip TPS because we talked in detail about it. Let's talk about U visa and VAWA. Those are humanitarian forms of relief. VAWA, Violence Against Women Act, is the older provision. Violence Against Women Act, let me see if there is a special, no. This is if somebody is the spouse or the parent or the child of a US citizen or lawful permanent resident, and that US citizen or lawful permanent resident is abusive, that this person is subject to domestic violence by the US citizen or lawful permanent resident family member, then this person can apply for immigration status through a self-petition. So like I said before, in the family-based thing, that normally somebody needs a US citizen or lawful permanent resident petitioner to bring them to the United States to become a lawful permanent resident. In this case, if the person who would do the petition is abusive and we can show that there was abuse, then this person can apply for that benefit to immigrate on their own. They do not need that US citizen or lawful permanent resident petitioner. And they can do this process, and the whole process is confidential. They do not have, I mean, ideally the person leaves the abusive situation and get additional services. And we on a regular basis, we refer people to other services like housing, shelter, domestic violence shelter. There is also possibility of other public benefits, CalWorks, for example. So then we file those self-petitions for people, but they have to show, for example, with the marriage, that they have been married to the US citizen or lawful permanent resident in good faith, that this was a true marriage. They have to show that the person is a US citizen or lawful permanent resident, that they have lived with the abusive spouse, even if it was just for a short period of time. They have to show the abuse. Usually it's a declaration, and if there is supporting documentation, they can show that. And they have to show that the abuse must have happened during the marriage, and also they have to show that they are a person of good moral character. So if we have a situation like that, then we can tell the person, and it doesn't matter whether the person entered legally or without documentation, this person, if they fit all the criteria, we would file an I-360 self-petition for that person. If the abuser was a US citizen, then we can also file the green card application for this person at the same time. And they don't have to rely on the abuser. The abuser is not in the picture, but everything needs to be truthful and legit. And in terms of abuse, any form of abuse counts, but it needs to be abuse. It cannot be a bad marriage. So the situation needs to amount to abuse. And abuse has many shapes and forms. It can be physical abuse, emotional abuse, sexual abuse, financial abuse, all kinds of abuse. So we would just have to, the client has to make a declaration, explain everything, how they met, where they met, how things were in the beginning, how things got bad, what are the types of abuse that he or she suffered. And it can be, the victim can be female or male, can have any gender. It's not focused only on women. And then we, submit documentation. If there is a restraining order, we submit that. If there is a police report, we submit that. And then, but the process is a self-petition so that the person doesn't depend on the abusive spouse, for example, and the goal is lawful permanent resident status. The process is lengthy, but it is good. We have CalWorks funding to do those VAWA petitions and also the U-Visa petitions. So please, if you come across somebody who is a victim of domestic violence, please refer them to us. We screen them, and if we think that this person qualifies, we are very happy to file those applications. We have a little bit of wait list, but we definitely do our best to serve those people. And we if they qualify for CalWorks, we can serve them for free. If they don't qualify for CalWorks, we may have another grant that they could fall under, so that we really try to provide free legal services for people who are victims of domestic violence or violent crimes. That's the VAWA self-petition in a nutshell. Then we have the U visa. That is a newer process. It started in 2000. We didn't have regulations for a long time, but since 2007, we can also file U visa applications. And those are for victims of domestic violence and violent crimes. And also the goal is, after having the U visa for 3 years, in the 4th year to apply for lawful permanent residence and later for citizenship. But the U visa is based on a qualifying crime. The Immigration and Naturalization Act lists certain crimes, and those are, domestic violence. Among them, the ones that we see the most is domestic violence, felonious assaults, also kidnapping, murder, rape, sexual assault. So those are the crimes that we see the most. So when we check whether somebody qualifies for a U visa, we need the police report. So if people want to have a consultation, see if they qualify for a U visa, we really need to see the police report, whether they have a qualifying crime. And then also we have to see whether they cooperated with the police. In the VAWA context, this doesn't matter whether it's a crime or not, whether there was any cooperation with the police or not. But the U visa is based on somebody is a victim of one of these crimes, cooperated with the police, suffered substantial abuse, and qualifies for the U visa. So we have to show those things. And that's why we also have to look at the police report. If somebody says, oh, I don't want to press charges, and did refuse to cooperate with the police, then that may be difficult. For U visa also, in the U visa context, it does not matter whether the person has any relationship to the perpetrator and whether the perpetrator has legal status or not. So it could be in a domestic violence situation that the couple is married, but none of them has legal status here, or they are not married and nobody has legal status, or it could be a crime that was perpetrated by a stranger, or so it's very flexible in that. Also in the U visa context, you can have derivatives, children under the age of 21, siblings under the age of 18 if the victim was under the age of 21 themselves. U visa is very flexible. I should mention, in the VAWA context also, the applicant can have derivative children who can apply with them. So it's both are very important forms of relief, particularly for people who are undocumented. And we always check whether somebody qualifies for U visa or for VAWA. And for both cases, if it involves domestic violence, we have CalWorks funding for that. So if they are CalWorks eligible, they don't have to have CalWorks. For us, it's only important if they are CalWorks eligible, then we can help them and their derivatives under CalWorks. Otherwise, we look if we have another grant and possibly, hopefully, can help them for free as well. In regards to the U visa also, so the first thing is, the U visa is a very lengthy process. They are only issuing 10,000 U visas per year. So immigration is very backlogged, but they are accepting the U visa applications, but they are pending for many years. The Biden administration started something that they check on the validity, on the viability of a U visa application earlier on. And if they determine that this is all good, they issue an interim deferred action status, protection against deportation, and also a work permit for that. And that used to be done at the very end. They just couldn't approve the U visa application because a visa was not available. So they gave the deferred action status instead. Now the Immigration Service makes an effort that they are checking that already earlier on, and they have made progress. So, but still U visa applications are pending for a few years before they get that interim status if everything looks good. And also work permit. After the interim status, when people finally are ready and a visa, the U visa, the actual U visa is available for them, then they get the U visa. That U visa is good for 4 years. And they need to apply for lawful permanent resident status for the green card within the 4th year. If they don't do this, the U visa expires and they are undocumented again. So in the 4th year, they need to apply for the green card. And once they have had their green card for 5 years, they can apply for citizenship. And also in the U visa context, people can apply from outside the country as long as the crime that they were the victim of happened in the United States. But a lot of people obviously apply from within the United States, but they may have derivative dependent children abroad. So there can be a consular processing component to it as well. So if they have dependents abroad, that they can bring them as well. In the VAWA context, there is something similar as well. So this is really in a nutshell, but if you identify somebody who is an immigrant, who is a victim of domestic violence or a violent crime, then it's absolutely worth checking whether they could qualify for a U visa or for VAWA. And they should be encouraged to leave the abusive situation if it was based on domestic violence. And there are resources available. And like I said, we have CalWorks funding. We could do those cases under CalWorks. So I definitely want to mention that. Are there any questions?
We have a question related to DACA, but I'll leave it until you go through more of the slides.
I think probably I would leave it at that, because what I have left is cancellation of removal, asylum, and SIJS. So I probably would refer to the slides. I would say the only thing is with special immigrant juvenile status, asylum, I think we are aware if somebody, fears or persecution is in their country, and they came here and they want to apply for asylum, that is an option, but they will need to do it within 1 year of coming here. We usually refer people out, like I mentioned, East Bay Sanctuary Covenant, or Lawyers Committee. Those are the main organizations that we refer people out. Cancellation of removal is something if people are in removal proceedings and they have, they can show exceptional and extremely unusual hardship to a U.S. citizen or lawful permanent resident spouse, child, or parent, and the applicant has lived in the United States for 10 years or more. But that is only something available in removal proceedings, and I do not encourage people to provoke situations where they end up in removal proceedings. So that is something, if people think about those things, that would need a really special, consultation. But that can be very tricky, but it's only for somebody who is in removal proceedings. And then special immigrant juvenile status, I just wanted to mention briefly, this is for people who are under the age of 21 and they are declared dependent on a juvenile court or placed in custody of individual or entity appointed by the court, of an individual or an entity appointed by the court, and they must show that the reunification with one or both parents is not a possibility because of abuse, neglect, or abandonment. So we check for that too. Sometimes, in the DACA context, if there is one parent who is abusive or they were neglected or abandoned by one parent, they may qualify for that special immigrant juvenile status, which also then leads to the green card if people qualify. So I just wanted to mention those three, and I would think I leave it at that so that we still have, the possibility for questions. Know your rights. It's in the slides, and thankfully we haven't heard about a lot of enforcement activity at the moment. But if there are questions about U visas, VAWAs, and other things, please go ahead. I try to answer them.
Yeah, thank you so much for this informational presentation. There's one question about parents with the U visa. If a parent recently received a U visa petition, can they petition for unmarried children above 21 if they have DACA?
So yeah, we always, when we do U visas, we always check who can be derivatives. So if an adult petitions for a U visa, applies for a U visa because, let's say, the person was a victim of a violent crime, then if they have a spouse, that spouse can be a derivative and can be filed at the same time. And children under the age of 21 can be filed at the same time. If that child is still under the age of 21, but for some reason that child was not part of that initial application for the U visa, that derivative application can be filed after the person received the U visa, but this application needs to be filed while the child is still under 21. If the child then gets older while the application is pending, not a problem. But it needs to be filed if it was not filed at the same time, as long as the child is under the age of 21.
Thank you. And there's one additional question I think we can take before I hand it over to Leah to wrap us up. So in VAWA cases, can someone with no physical proof or police reports for evidence, such as can hospital and medical records be sufficient to support the application?
Absolutely. In the U visa and in the VAWA, the standard is any credible evidence. Now, in a U visa context, we need the police report, we need certain tangible things because it's hinged on a crime. So we need that. Under VAWA, it's pure domestic violence in any shape or form. If there is no police report, then there is no police report. It's not required. If there is no restraining order, it's not required. Now, the thing is, the more documentation you have, obviously, the stronger the case and the easier it is to make the case. But even if there is no physical evidence, the classical things, you can still file a VAWA self-petition. It's just more work, and you have to find other forms of proof. It could be declarations. It could be that everything relies on declarations, and that's fine. But then one has to do a really good job to explain everything in detail, and everything obviously needs to be truthful and correct. So the VAWA self-petition is very flexible in showing each element of the application. And sometimes you really have to become creative, especially if the person, the victim, was isolated and things like that. But any credible evidence is possible.
Thank you so much. Okay. Leah, do you think we have time for this last question or should we start wrapping up? Maybe we can follow up in this.
Let's go ahead and do it. And then if people have to log out a little bit early, they're going to get the recording too. So let's go ahead and get it done.
Sounds good. Okay. So for this additional question, if someone acquires a disability status, can that person take their citizen test in their own language or with special accommodations?
So there are two possibilities. One is, let's say there are disabilities, and then you can definitely ask for accommodations. Let's say somebody is hard of hearing or needs a wheelchair and things like that, then you would explain that in the application. There is space for that. There are questions for that. Then that's totally fine that they can use their hearing aids, or that things might take a little bit longer, so that people that the interviewing officer is aware of that. So that's one thing. That's accommodation. The other disability that I talked before is this severe mental disability, and it could be Alzheimer's, dementia, or it could be a developmental disability as well. Those things, then there it goes beyond accommodation. That's then that this person really, if that is done properly in the form N648, and that form was accepted by immigration, and they say, yes, this person really has this disability, then this person does not need to do anything in English. Everything is in that person's language, and they may or may not even honestly be able to answer, basic questions. Usually you have then a family member who is there as well with them, and often an attorney who goes with them. And they certainly do not have to do any test, any civics or history test. And some people, they may speak English, and they may not have to be excused from the English, test, but they may not be able to learn, the civics and history because of the mental, disability situation. So that goes way beyond accommodation, but that's also, harder to get.
Thank you so much, Eleanor, for your time and detailed explanations.
You're
And
very welcome.
the updates. I will pass it over to Leah now for next steps.
Great. Thank you so much, Eleanor and Deanna. I really appreciate everything that you shared today. Thanks everyone for coming. We really appreciate you being here and asking all these amazing questions.